Let's talk about a classic homeowner headache. Something in your home gets damaged, and suddenly you're in a standoff trying to figure out who's supposed to pay for it. Is it you, or is it your homeowners association? Well, today, we're going to dig into a real court case to find the answer, and trust me, it's probably not what you think.
All right, let's put you in this situation for a second. Imagine you come home and there's been some kind of disaster in your condo. Your first thought is probably, phew, okay, the HOA's big insurance policy will cover this. But what if they just say no? What if they point to some rule in a giant document you probably skimmed, at best, when you bought the place? That is the exact nightmare one couple walked right into.
So let me introduce you to Jerry and Patricia Gravelle. They owned a condo, Unit 14, in a development called Village Parc. They had no idea they were about to get into a huge, stressful fight with their HOA, all because of a problem that started deep underground, completely out of their sight.
It all kicked off with one messy, disastrous event, a sewer backup. I mean, nobody wants to deal with that. It caused damage to their place, their neighbors' places, just a frustrating situation all around. But they figured it's what insurance is for.
And this is the number that this whole thing is about, $6,697.70. After everything was assessed, this was the chunk of the repair bill that insurance wouldn't touch. This is the amount the Gravelles were sure their HOA should pay, and it's what turned a gross plumbing problem into a full-blown legal battle.
So the Gravelles did what any of us would do, right? They got on the phone and started calling the insurance companies, trying to find someone to cover the bill. But pretty much right away, they slammed into a brick wall.
Okay, so first, hurdle number one, they find out their own personal policy has an exclusion for sewer backups. Ouch, that's a tough break. So they do the next logical thing. They file a claim under the HOA's big master policy with Travelers Insurance. And Travelers does pay a little bit, just under $340 for damage to what they call common elements. But that big number, the nearly $6,700 for the damage inside the Gravelles' home, denied. Flat out denied. And that denial, well, that's where our story really gets interesting.
And just like that, this whole thing stopped being about a sewer backup and started being about paperwork. The entire case would end up hinging on one single, legally binding document that governed the whole community, and the specific words written on the page.
And here it is. This is the key piece of evidence. What you're looking at is a page from the Village Parc CC&Rs. Now, this isn't just some friendly welcome packet they give you with the keys. No. This is the official, legally binding rulebook that every single homeowner agrees to follow.
And just so we're all on the same page here, CC&Rs stands for Covenants, Conditions, and Restrictions. The easiest way to think about it is like a constitution for the neighborhood. It spells out in black and white what the HOA has to do and what you, the homeowner, have to do. It's a contract, plain and simple.
Okay, this is really where the rubber meets the road. According to these CC&Rs, the unit, which is the owner's problem, includes all the interior stuff, the paint, the floors, the drywall. But the common elements, the HOA's responsibility, are the shared bits, like the pipes running between the walls. So the pipe that broke was a common element, but all the damage it caused was to the unit. See the problem? It's a huge gray area.
All right, so with the insurance company saying no, and the HOA digging in its heels, the Gravelles took their case to a hearing. Both sides showed up ready to fight for their interpretation of those rules.
The Gravelles came in with what felt like a slam dunk argument. They said, look, the HOA paid for this exact kind of interior damage for other people in 2011 and 2012. And get this, the HOA board itself, which Mr. Gravelle was on, actually voted in November 2015 that, yeah, their insurance should cover this. But the HOA's defense? Super simple. They basically said, none of that matters. What matters are the words in the CC&Rs. Any past payments were mistakes, and a board vote can't just change a legal document.
And you can see why the Gravelles felt pretty good about their chances, right? I mean, look at this history. In 2011, the HOA pays for repairs. In 2012, they pay again for somebody's kitchen cabinets. Even their own board agreed with them at first. They had this clear pattern of behavior on their side. But the big question was that going to be enough in the eyes of the law? So, after everyone had their say and the judge reviewed all the documents, it was time for the final decision. This was the moment of truth, the verdict that was going to settle this whole expensive mess, one way or the other.
And the verdict? The judge sided with the HOA. The entire decision came down to this one crucial point from the ruling. The judge said the CC&Rs were clear.
They explicitly put the homeowners, the Gravelles, on notice that the HOA was not required to insure the inside of their unit. Basically, the law assumes that from the day they bought the place, they knew the rules.
And this is the final nail in the coffin, the official court order dismissing the Gravelles' case. It was over. And that meant that they, the homeowners, were officially on the hook for that nearly $6,700 bill. So what can we all learn from this expensive, frustrating ordeal? First, and I can't say this enough, read your documents. The CC&Rs are a contract you signed. Second, know your personal insurance policy inside and out. Make sure it plugs any gaps the HOA's policy has. Third, and this is a big one, just because an HOA did something in the past doesn't mean they're legally forced to do it forever. And finally, the law assumes you know the rules. Saying, "I didn't know," is just not a defense.
It all boils down to this, and yeah, it might be a little uncomfortable to think about. We all get that mountain of paperwork when we buy a home, and it's so easy to just stick it in a file cabinet and forget about it. But as the Gravelles learned the hard way, the answers to some very, very expensive questions are hiding in that fine print. So have you read yours?